Greetings. Am I being amplified? I can't really hear myself.
Yes.
Yeah? Okay, great.
Speak directly to me.
Speak directly into the swallow that microphone, as the folks in radio would say. Welcome to the Reynolds School of Journalism's annual First Amendment Forum. My name is Patrick Feil. I'm Assistant Professor of Media Law at the Reynolds School, and I get to welcome you and introduce our illustrious guest and set the stage for our discussion. First, I want to extend a heartfelt thanks to Warren and Janet LaRude. Warren is Professor Emeritus at the Reynolds School and a longtime media law professor. And he and Janet are committed to ensuring the First Amendment remains a core value at the University of Nevada. Their generous First Amendment endowment helps make this event possible. So please join me in thanking them. I'd also like to thank KUNR for their promotional support of this event, along with One for All, part of the Free Speech Center at Middle Tennessee State University, which provided a grant. And of course, I'd like to thank the wonderful staff at the Reynolds School and here at the Joe Crowley Student Union for helping everything run so smoothly. So thanks to you all as well. Our guest tonight is Professor Jane Kirtley. Jane is the Siller Professor of Media Ethics and Law at the Hubbard School of Journalism and Mass Communication at the University of Minnesota, where she directs the Siller Center for the Study of Media Ethics and Law. Before that, she was Executive Director of the Reporters Committee for Freedom of the Press for 14 years. She practiced law in New York and Washington, D.C., and was a newspaper reporter in Indiana and Tennessee. She has a law degree from Vanderbilt University's Law School and bachelor's and master's degrees from Northwestern University's Medill School of Journalism. Her accolades include the Peter S. Popovich Award for Freedom of Information, the Edith Wortman First Amendment Matrix Foundation Award, the National Freedom of Information Hall of Fame, the National Scholastic Press Association's Pioneer Award, and the John Peter Zenger Award for Freedom of the Press and the People's Right to Know. Among her many publications are Media Ethics Today, a college-level textbook, and the Media Law Handbook, which is published by the U.S. State Department and translated into 9 languages. She regularly travels all over the world on behalf of the State Department to talk and teach about the First Amendment, including to Sao Paulo, Brazil next month for International Press Freedom Day. I may be biased, but I consider Jane to be one of the most important and influential thinkers on press freedom and media law that we have. If you want to know more about what I think of her, you'll have to read the acknowledgments in my new book, Bad News Travels Fast: The Telegraph, Libel, and Press Freedom in the Progressive Era. But more seriously, and speaking of libel, Professor Kirtley has taken up a more difficult task tonight than we might assume. Her talk will raise questions about what has become First Amendment conventional wisdom, that free speech in a democratic public sphere requires that public officials and public figures should face a steep legal challenge when they sue critics and commentators. You might have heard that Justice Clarence Thomas of the U.S. Supreme Court recently challenged the case at the center of that tradition, New York Times versus Sullivan. It might surprise you a little more to hear the words of another justice who has questioned that doctrine, saying, quote, "We should appreciate that people who did nothing to ask for trouble can be greatly harmed when something goes around the internet and everybody believes something false about a person. That's a real harm, and the legal system should not pretend that it's not." That's Justice Elena Kagan in her 2010 confirmation hearing. So let's consider those challenges at face value and confront the question of whether our democracy would benefit from a re-examination or a reconsideration of its robust protection for harsh and even harmful words about people with power and influence. As you listen, please think of some questions of your own. As usual, we'll make sure that we dedicate the last 30 minutes of this forum to your questions. So now, please help me welcome Professor Jane Kirtley.
Good evening, everybody. I enjoyed your commercial for your book, Patrick. Nothing like a little commercial speech mixed in with protected speech. Thank you to Warren and Janet and to KUNR and everybody else, and particularly to Patrick for inviting me to come and speak here to you tonight about some things that I think are really terribly important as we navigate our way through what passes for contemporary discourse. The title of my presentation, as you know, is Uncommon Law, the Past, Present, and Future of Libel in America. And for those of you that are familiar with our legal system, you know that this is sort of a play on words. Our system of law, which we inherited from England, is the common law system. Common law system briefly means that we rely very heavily on judges to make our law. And you've probably heard people say, that's judicial activism, judges shouldn't do that. But the reality is that that's what happens. Yes, of course, Congress and the legislatures pass statutes, and that's an important part of our law too. But if you follow the courts at all, you know that when courts hand down decisions from the highest court in the land, the U.S. Supreme Court, all the way down to state Supreme Courts and lower state courts, that forms precedent that then becomes binding on other courts that are in that same jurisdiction, or in the case of the U.S. Supreme Court, everybody in the country. That's the way we do it, and that's the way we've been doing it for a very long time. Other countries take a different approach. Most of them rely on the Napoleonic Code, the civil code system it is often called, where courts are important, but in no way are they as significant as the voluminous codes and statutes that are passed by legislatures and parliamentary bodies in all those jurisdictions around the world. So to say that we're dealing with uncommon law here is really saying how unusual it is to formulate the kinds of protections that the Supreme Court has recognized in the area of false and defamatory speech. So I'm going to talk a little bit about that this evening, and then talk about some of the implications that flow from that. I start with a question which was really posed by the current President of the United States, Donald Trump, even before he was president, which is that he says that it's time to, as he put it, open up the libel laws. And it's a very provocative approach for him to take, in large part because for many, many years, libel law in this country has been relatively quiet, not non-existent, but because of some of the precedent that I'll be talking about in a second, particularly for public figures and public officials, the difficulty of successfully bringing a libel suit deterred many of them from doing so. But the tide has turned. Situations have changed, and we're experiencing a growth in libel suits that are brought both by public officials and public figures. There are too many to enumerate here, but I'll just give you a few examples. Sheriff Joe Arpaio, Nicholas Sandmann, the kid that was on the National Mall during a demonstration, John Benet Ramsey's brother, the young girl that was mysteriously murdered in Denver, Colorado quite a few years ago. Stormy Daniels brought a libel suit against the President of the United States. So there's lots going on there, and part of the question, I guess, is why? President Trump says that our current libel laws are a sham and a disgrace. And he added something else that I think is quite significant. He said, they do not represent American values. And so what I'd like to explore with you this evening is that true? Do they really not represent American values? And do we need to overhaul or open up the libel laws? Let me talk for a few minutes about background, because I think we need to have at least a little common knowledge and understanding, and at least some of the legal terms, as complex or boring as they may seem, in terms of what we're talking about with U.S. libel law or defamation law. Libel law exists and has existed for generations. If you go back and look at the Bible, there are references to libel. It's in Shakespeare. It goes back a long way. Western society, Eastern societies, other societies in between have articulated the idea that individuals have a right to having a good reputation. Justifiably, I guess I would add, but we have a right to reputation. And so if people are going to hurt our reputations, they better be doing so telling the truth. If they're not telling the truth, then that is something that the law should give some kind of remedy for. Now, this is not exactly the same thing as the much utilized term these days we hear of fake news. At least I don't think it's the same thing. The president said some time ago that he invented the term fake news. I'm not sure that that is true. I think we can trace it back certainly to the Nazi era, where the Germans spoke frequently about what they called the lying press. So we've certainly had elected officials who have had their disagreements with the press and have labeled the press as something not to be trusted, In fact, something to be distrusted and discounted and disbelieved by the electorate. But that's different, I would suggest, from libel, although the two can overlap, because the essential element of libel is not only falsity, but also that it actually harms somebody's reputation. So how did libel law evolve in this country? Well, as I said, we inherited English law and English common law precedent. And if you know your English history, you know that there was a time when the notorious Court of Star Chamber, which met notoriously in secret, considered issues like libel, but in the very specific context of criticism of the crown, the king or the queen. And it was really not important whether that criticism, whether those statements were false or true. The idea was that it was disquieting to the populace to have their God-anointed rulers questioned. In extreme situations, it might lead to an uprising or rebellion, and we couldn't have that. So to criticize the government was seen as, in some cases, actually a capital offense. And that heritage was something that, again, we brought to this country, or the English brought to this country when the colonies were established. If you know the story of John Peter Zenger, the courageous printer, an immigrant, who printed a variety of tracts during the reign of the colonial governor in New York while we were still American colonies, you know that he published these tracts anonymously, and the discussion of the importance of protecting anonymous speech certainly goes back at least to his era. You know that many of the people that became the driving forces behind the American Revolution could not criticize the government with their names attached to it. They would face seditious libel or treason charges. So what Zenger did was publish their tracts without a name attached. But because he didn't put a name on it, he himself was subject to criminal prosecution for having published these things that disparaged the colonial governor. In, at least to me, in the media law area, I guess I would say, the first instance of jury nullification, the jury that was impaneled refused to convict Zenger, even though under the law of the time, he probably was guilty, pretty unequivocally so. But they wouldn't do it. They were so offended by the idea that criticizing the colonial government could lead to somebody going to jail, perhaps indefinitely, that they refused to convict. For many years after that, and Patrick's Files book goes into this, there was libel law in this country, and for the most part, it was state law. Different states had different standards. You could become vulnerable to suit for the same story in different states, as it would be the case today. But the idea that libelous speech should enjoy any kind of protection under the First Amendment really wasn't in play at that point. The Supreme Court actually hadn't done much in the way of construing the First Amendment in other contexts either, but this was just not an area where they were inclined to examine the question or even asked. It was not until 1931 when a case that arose in where I live now, Minnesota, brought the question to the fore in a kind of an indirect way. There was a guy by the name of J. Neer who published a scurrilous publication called the Saturday Press. Scurrilous, I'm really using the word that was used by the people that tried to stop him from doing it. They were prominent officials living in Minneapolis and St. Paul, police chiefs, mayors, people like that, people that we would call public officials, who didn't like the fact that J. Neer was reporting to his readers what many of the more establishment newspapers were not, which was that these individuals were firmly in the pocket of organized crime that was rampant in the Twin Cities, particularly during the Prohibition era, when bootleg liquor was being run down from Canada into the United States. You think of Chicago for that, but Minneapolis-St. Paul was an important part of that too. In doing this, though, J. Neer indulged in some language that many people found extremely offensive and extremely anti-Semitic. And the good governors of Minneapolis and St. Paul declared the newspaper a public nuisance and demanded that it should be stopped from being published, and that if J. Neer wanted to resume publication, he would have to submit his paper for prior review by a court before he could continue. So you're thinking, so what does libel have to do with this? Well, part of what was going on was that the officials were claiming, of course, that what he was saying about them was harmful to their reputations. But when the case went to the U.S. Supreme Court, it really turned on this question of prior restraint or prior review. But in some very important language that was not part of the governing law of the case, it's what lawyers and judges call dicta, the Supreme Court gave a laundry list of speech that was not deserving of First Amendment protection. And one of the things it mentioned was libel. So at that stage, we really didn't have any idea that libelous speech, false and defamatory speech, would be included in the protections of the First Amendment. It took quite a number of years before the Supreme Court went back and looked at this question again. And as is often the case, great cases often emerge from perilous times. And the time that I'm referring to was during the Civil Rights Movement, when the New York Times published what today we would call an advertorial, which recounted how civil rights activists, Black Americans and others, were being treated by law enforcement in the South, places where they very much wanted to maintain the segregation that had become part of their way of life. The New York Times, like many other northern publications and broadcasters, were coming down to the South to cover what was going on there, and the people that were living in the South who wanted to maintain the status quo didn't like it. When this advertorial appeared, as I said, it recounted the way law enforcement figures in a city in Alabama had been treating protesters and activists, including people like the Reverend Dr. Martin Luther King. A guy by the name of Sullivan, who was a government official in the city, who was not named in the article, said, by implication, this is about me. You're criticizing the police, I'm a city commissioner, therefore you're criticizing me, and you've got mistakes in this, factual mistakes. You've got the wrong song that the protesters were singing. You said that the police ringed a historically Black college campus when they never did that. You said that they locked the door to the dining hall to starve the students in submission. That never happened. And so therefore, with all of these falsehoods, I should be able to recover lots and lots of money from the New York Times. And guess what? I mean, if you've ever read To Kill a Mockingbird, you can imagine what happened. The jury in Alabama was happy to rule in favor of Sullivan and against the New York Times, and awarded him an amount of damages that seems minuscule today, but was huge at the time. Now, again, this is all under Alabama law, and Alabama law at the time was very favorable to the plaintiff. They had to prove very little in order to prevail, and the defendant had to prove truth, which, strictly speaking, the New York Times could not do because these statements, for the most part, that were identified were in fact false. So what happened? The New York Times says, okay, if we're going to be subject to these kinds of libel suits and these kinds of damages, that is going to put us at significant financial risk if we continue to report in the way we are, as would any other news organization that would cover these topics. This is a scary prospect. This might deter us from going forward. It's an example of what we sometimes hear called the chilling effect. It would chill our speech. So the New York Times decided to take the case to the U.S. Supreme Court to make the novel argument that libelous speech should be protected under the First Amendment, at least under certain circumstances. So that's what they did. And the Supreme Court, to the surprise of Benny, bought it. Justice William Brennan wrote the opinion, and there's much to say about it, but I will just talk a little bit about what he said. Essentially, he said, where public officials are concerned, the public has a right to criticize them, and by extension, so does the press. We don't believe in seditious libel in the United States anymore. The Sedition Act, which had been enacted at the end of the 1700s, expired in its own terms in the early part of the 19th century, and those who had been imprisoned for sedition were pardoned by President Thomas Jefferson. Said the problem here is, we're not a monarchy anymore, and people have a right to criticize elected officials, and what's more, elected officials, aside from the power that they wield anyway, have this unusual status, which is that if they're speaking in their official capacity, they're immune from most libel suits. So they can sue you, but you can't sue them. And Brennan says we need to level that playing field. We need to give people the right to criticize elected officials without fear that they will be subjected to crippling damages claims and even just nuisance lawsuits. Because if we don't do that, we're going to chill and limit the robust debate that is so necessary in a free society. I'm not going to quote a lot of his language, but I will quote one thing. He says, "The pall of fear and timidity imposed upon those who would give voice to public criticism is an atmosphere in which the First Amendment freedoms cannot survive." In other words, the First Amendment means nothing if it does not protect our right to criticize those who we elect to public office. Well, as you can imagine, this view was seen by many as a really positive thing, because significantly what Brennan said was not that there was an absolute protection if you publish something false and defamatory about a public official, but that the public official would bear a very heavy burden in order to prevail. That public official would have to prove that you acted with what is called actual malice. And those of you who have studied the case know that actual malice does not mean the dictionary definition of ill will, we don't like you, although that might be relevant evidence. It has a very specific meaning. It means that you publish with knowledge that what you're publishing is false, or with reckless disregard of whether it is true or not. In other words, it's basically doing what your ethics professor would tell you you should never do, which is publish something that you don't know to be true, and that with some reasonable effort on your part, you could establish whether it was true or not before you published it. But make no mistake, it's a heavy burden to prove that. It's a very heavy burden to prove that. And public officials caught on to that pretty quickly. A variety of scholars, including a very important First Amendment scholar, called it an occasion for dancing in the streets when this opinion was issued by the Supreme Court, but a lot of public officials did not agree. By the way, in the meantime, in the same term, the Supreme Court considered a case called Garrison versus Louisiana, which took on the issue of criminal libel law. Most of us think as libel law is purely a civil matter. You sue somebody, if you win, you get lots of money. But many states at that time, and still quite a number of them, have criminal libel statutes where, yes, you can be arrested, your materials can be seized, you can go to jail, you can pay big fines for criticizing somebody, publishing something false about them. In Garrison versus Louisiana, the court said that the actual malice standard would apply to criminal libel statutes as well, but they did not abolish them. And I can tell you that in my state of Minnesota, we still have criminal libel prosecutions more frequently than you might expect. In any event, the actual malice standard was a seismic shift in the way libel law was approached in this country. And in the ensuing years, the Supreme Court re-examined the standard from a variety of angles. One that's probably important in this discussion is in a case called Gertz versus Welch, where the Supreme Court looked at the question of when somebody becomes a public figure and what constitutes a public figure, and most significantly, what standard of fault would apply if somebody's not a public figure. In other words, does the actual malice standard apply in other circumstances if the plaintiff is not a public figure? And what the Supreme Court said that's relevant to this discussion, in addition to talking about the protected status of pure opinion, was that the states could set the standard for themselves, which basically gets us back in this context, other than the Sullivan and its progeny kind of standard, to the idea that the states get to decide, subject to the requirement that there must be some demonstration of fault. It could be simple negligence, not living up to the duty of care that you have, or it could be actual malice. And there are a few states that use the actual malice standard for any kind of plaintiff in a case against a news organization. But most states use a lower standard. The idea being that people who are not public figures, shouldn't have to do that much, unless they're seeking something beyond the damages that would compensate them for their out-of-pocket harm or their physical, the physical manifestations of the publication. If they're seeking what's called punitive damages, the damages that are really a fine for speaking freely and that have more to do with the old criminal libel and seditious libel standard than most people would like to admit. What happened in the years after Sullivan, having to do with this issue of punitive damage, was an escalation of punitive damages. And there are lots of theories about why this happened: growing public distrust of the news media, general disquiet with the media getting out of control, inappropriate behavior, I mean, you name it. And there were more and more of these very large punitive damages awards going into the multi-million dollars in the 1980s and 1990s. And there were a lot of people that were very concerned about this. Media organizations certainly, their lawyers certainly, but even judges were saying, we can't go on like this. And what's more, they said there's a fundamental problem here, which is that we're getting away from the question of whether the truth was told in this story and focusing much more on the behavior of the journalists. And that's problematic. And, you know, maybe we need to think of a different way to configure libel cases going forward. There was a study that came out of the University of Iowa, which you can take for what it's worth, and I don't mean to disparage the researchers, I'm just kind of questioning the honesty of the people they were talking to. They discovered that the typical libel plaintiff at the time was a white male individual, prominent in his community, not someone who routinely sued anybody for anything. In fact, this was usually the first suit they had ever initiated. And they sued because they would try to contact the news organization, try to get some kind of satisfaction, correction, something like that, and they were not getting a response. And so their feeling was the only way they could vindicate their reputation was by bringing a lawsuit like this. But even so, if they weren't able to prove actual malice, they would not be able to succeed in that lawsuit. So various people, including Judge Pierre Laval in New York, federal court in New York, something called the Annenberg proposal that oddly enough came out of Northwestern University, the Uniform Law Commission, came up with theories that said, for example, that libel cases should be split in two, and you should have a truth trial to try to determine the truth of the statements, and then a separate trial for damages if you were able to demonstrate that indeed the publication was false. And the issue of the conduct of the journalist would become a very secondary question. The Uniform Law Commission came up with something called the Uniform Correction or Clarification of Defamation Act. If you know anything about the law in many states, you may be aware that there are so-called retraction statutes. And people sometimes think that a retraction statute means that if a news organization retracts a story, then that makes the libel case go away. It doesn't. It simply reduces the damages that can be recovered. But what the Uniform Correction or Clarification of Defamation Act would do would be it would take away damages, providing that your clarification, your correction, your retraction was published in a prominent way. Again, the idea is we're shifting to trying to underscore the notion of finding the truth here, rather than looking so much at the issue of the conduct of the news organization. Well, many of the people that supported this, I have no doubt, were very sincere. I mean, I was even involved in this peripherally as an opponent of it. Lawyers that I respected, judges that I respected, thought it was a great idea. I saw it as a way that news organizations might be tempted to essentially throw a reporter under the bus in the interest of trying to make a case like this go away by basically hanging the reporter for getting something wrong. But whether I'm right or they're right, the bottom line is most states weren't interested, and there are only 3 states that have adopted some version of this statute, so it's not what you would call a popular statute. So now we have this strong, robust libel law that's been there since 1964. We have all of the cases that have come down since then to expand it to cover a variety of circumstances and a variety of people. And now add to that, into that interesting mix, President Donald Trump. And President Trump, as I said, has been a strong proponent of New York Times versus Sullivan and its progeny, and has often conflated it with the idea of fake news. So what do we mean when we use the term fake news? If you read the Washington Post, you know that Margaret Sullivan, who writes a lot about media issues, wrote some months ago that she thought the term fake news should just be done away with because nobody agreed on what it means. I'll tell you what I think it means, for what it's worth, and what I think it means, should mean, is when a news organization or some other speaker or publisher deliberately chooses to publish information they know to be untrue with the goal of misleading the public. That's how I would define fake news. I don't think that's how President Trump defines fake news. Some have said he defines fake news as anything that makes him look bad. But whatever it is, I think we have to distinguish it from libel because it could be the same, but it isn't necessarily the same. Do we mean propaganda? You know, I think a lot about the increasing information we're getting about Russian and other foreign actors' interference in our elections. And I will just tell you anecdotally that I was on a Fulbright at the University of Latvia in Riga in the spring of 2016. One of my students was from St. Petersburg, Russia. And she came up to me in March of 2016, and she said, "Professor Kirtley, the Russians are messing with your election. Don't you know that?" And I said, "Oh, Alexandra, I'm sure that's not right." She wasn't telling me fake news. She was telling me the truth, but we didn't know it. Most of us, at least, didn't know that that was happening. To me, that's fake news. That's fake news. And when you add into things like the use of bots, the practice of brigading, you can see that it's getting a lot more difficult to get to the truth, separate and apart from the issue of maintaining somebody's reputation. Which brings me back to the question, what is libel for? When Justice Gorsuch was still a federal judge in the 10th Circuit, he wrote in an opinion that libel is not about compensating for damage done to a false reputation by the publication of hidden facts. It's about protecting a good reputation honestly earned. And I think that's a great way to look at libel law. It's about protecting us from false statements. It's not about preserving an image, however carefully cultivated. And it's certainly not about shoring up statements from government officials or even from the federal or state governments themselves that prove to be untrue. Now that's what's going on here in this country. And I want to talk for a minute about how this contrasts with what happens in other countries. I talked about the difference between common law and civil code. One of the big differences, I think, between this country and many other countries, including countries like the UK and Canada and Australia that also have a common law system, is the degree to which they elevate the right of reputation and the right to dignity, which are not exactly the same thing, but are often conflated by the courts and by the codes in those countries. For the most part, the civil code countries have shown very little interest in adopting anything remotely resembling the New York Times versus Sullivan standard. In Canada and the UK, they've sort of flirted with it, and there are some versions of laws there and court decisions that sort of sound like the actual malice standard. For example, in the UK, it's called the responsible journalism defense, and if you run through the elements, it's very much like an actual malice standard. But they haven't taken the complete leap to adopting our standard. And I remember many years ago writing a paper for a conference in Canada where I was basically trying to defend the New York Times versus Sullivan standard, but I had to acknowledge that one of the kind of unlooked for consequences is that it invites probing into journalists' minds, their mindset, their orientation, why they're doing a story in the way they're doing it, that was never done before New York Times versus Sullivan because it was frankly irrelevant. You'd either publish the false and defamatory statement or you hadn't. And now when we start talking about fault, we have to figure out, well, did you act recklessly? Did you know this? And those kinds of questions open up a whole door into the newsroom that had been shut prior to that time. And I think that's one of the reasons the Canadians have not perhaps been as enthusiastic about the Sullivan standard as we have been here. But it's also the reason that Congress, not that many years ago, passed a law called the Speech Act. That's, of course, an acronym, but what that statute is about is preventing the enforcement of big libel judgments in other countries that don't have our standard or something very close to it. Because as you can imagine, what happened was that when nationals of other countries were upset with a U.S. news organization and knew that they couldn't prevail here, they'd go to a country that was friendlier, that was more oriented toward the plaintiff, get a big monetary judgment, and then bring it to this country to enforce it. Without getting too deep into the weeds, I'll just tell you that when we're talking about countries that we think have a comparable rule of law, we generally give full faith and credit to judgments that are rendered there. Comity is what the principle is called, and it's a very important one. But what the Congress did with the Speech Act was basically reject that, because they said, you know, one of the principles of the United States is that we want the free flow of information, we want robust debate and discussion, and we don't want people to be Russian oligarchs to go and bring a libel action in a place like England and then bring it back here and try to enforce it through the U.S. courts against U.S. publishers. So that's what the Speech Act is all about, and it's a very important defense for news organizations that operate internationally, which most of them do today, because whether they have physical presence there or not, they're there by virtue of publishing on the internet. That's great, as long as you're talking about U.S. media organizations. But what if we're not talking about U.S. organizations? The kind of Russian propaganda and so forth that I've alluded to is something that has caused a lot of concern in Europe in particular. And as a consequence of that, Europe, particularly the European Union, has said we need to do something about fake news. We need to do something to deal with this, to protect people, to protect the electorate from false information. And remember, Donald Trump has multiple times referred to the U.S. media here as the enemy of the American people. So you can see how this plays into the hands of those who are part of authoritarian regimes or represent extreme political viewpoints who are elected to political offices. This happened in a number of the former Soviet-dominated countries like Hungary, for example. You can see how this plays right into their hands if they can say, we're protecting the people from fake news by taking action to suppress it. And this is not just a theoretical thing. I could give you many examples. I'll just mention a few outside of Europe. Kenya, Venezuela, Philippines. These are all countries where journalists have been arrested on charges of publishing fake news. In Malaysia, they passed a law last year called the Anti-Fake News Act, which carries criminal penalties. Germany, we consider that to be a mature democracy, has a law that requires the removal of fake news within 24 hours, or the publisher faces fines of up to 50 million euros, which is a lot of money. The European Commission created a high-level group on fake news and online disinformation and has called for a new code of practices to regulate how information will be vetted and what consequences will flow from publishing it. There was a particular commission set up called the EU versus Disinformation.eu, which investigated claims of fake news, mostly but not exclusively Russian. And interestingly, the Dutch government repudiated it and refused to participate in it because a rather radical organization that was operating in the Netherlands said, what happens when they get going with this is that they label publications as disinformation and fake news, which gives government the license to suppress it. And they said that makes it impossible for the truth to emerge in the public debate. And that brings us back to the New York Times versus Sullivan rationale, because one of the toughest things to argue for Brennan or for anybody else who's trying to defend it is, what's the good of false news? What's the good of false information? How can it possibly be helpful to protect false statements? It can't be, right? And so we mustn't do it. What President Trump said recently was, I want to make it more fair from the side where I am, because things are said about me that are so egregious and so wrong, and right now, according to the libel laws, I can do almost nothing about it. And how can that be a good thing? If you're a public official and people are lying about you, undermining your administration, just like the colonial governor in New York probably thought his administration was being undermined. Why wouldn't you want to ensure that that kind of information could be suppressed, if only to maintain the stability of your regime? So it's a dictator's dream to do away with something like New York Times versus Sullivan, because there's a very important point about this, which I'm sure you're already ahead of me on this, which is who's going to decide which news is fake and which news is true? Are we going to establish truth tribunals to decide whether something is true or not, as was proposed in the 1980s and 90s with the various proposals like the Annenberg proposals? Should we go back to letting the states decide, as Justice Clarence Thomas proposed in his concurring opinion in the libel case that the Supreme Court decided not to take a few weeks ago? Patrick mentioned that to you. The theme, I think, of Thomas's remarks were essentially that we got along fine when the states decided what the standards would be, and at least for people that aren't public officials, we ought to go back to that and trust in the good judgments of the state to make those determinations, presumably extending to the good judgment of the state of Alabama at the time that New York Times versus Sullivan was being argued. And again, as I mentioned, very, very heavily weighted toward the libel plaintiff as opposed to the news organization. To me, the question ultimately turns on whether we trust the government to determine what truth is. I often explain to my students, and as a lawyer I'm very aware with this, that I personally think that truth is a very elusive thing, and courts are simply not equipped to determine it. There are reasons for that, procedural reasons, evidentiary reasons. You all know, if only from watching television, that lots of times perfectly truthful evidence is excluded from a trial because it was collected in the wrong way, the police violated a rule, and the court excludes it because it wouldn't be right to include it. In other words, I think courts are better at doing justice than they are at finding the truth. So if you agree with that proposition, and you might not, then you would probably agree that it's not really a great idea to have the government deciding what is true and what is false, whether it's the judicial branch or whether it's the executive branch that makes those determinations. A very famous First Amendment scholar, Zachariah Chafee, wrote, "We must always be careful not to assume that the findings of a tribunal on a controversial issue are," and he writes this in all capital letters, "the truth." And even the Society of Professional Journalists Codes of Ethics talk about how one of the duties of journalists is to seek truth and report it, not seek the truth, because we know that truth is ever-changing, ever-evolving, and the search for it goes on forever. But as a commentator for the Federalist publication, I mean the current one, I'm not talking about the Federalist paper, which by no means could be characterized as a liberal publication, says that the logical conclusion of adopting a regime like this is that libel will be whatever the government says it is. Antithetical, certainly, to First Amendment values that we assume would require the kind of give and take, back and forth debate of unpopular viewpoints and ideas, which is the way historically we've gotten to truth in this country. Freedom of the press is too important to allow public figures to use the courts to silence publications of things they don't like or that make them look bad. So it brings us back again to New York Times versus Sullivan. Why does it protect unpopular speakers and speech? Doing away with it, Brennan would say, would deter those who would criticize official conduct, those who would voice their criticism, even though they believed it to be true, and even if in fact it is true, because of the doubt whether they could prove it in court or fear the expense of having to do so. And here's the thing about New York Times versus Sullivan. It protects everybody. Whatever your political viewpoint might be, New York Times versus Sullivan protects you. And I think that's something that sometimes gets lost in all of this debate and discussion and vilification of the standard. There have been many examples of public figures, themselves allegedly the victim of libelous speech, who have also been the beneficiaries of the Sullivan Standard as they lash out at their critics. And that's part of the price that we pay. We don't let the government decide what's the truth, what are the preferred ideas. And abolishing the Sullivan Standard, leaving it to the states, would leave us open to that, I believe. There's no debate, I don't think, in this era of the internet, social media, a variety of platforms, the decline of the legacy media, that the marketplace of ideas is imperfect. We like to think that in the marketplace of ideas, when bad ideas are exposed to public scrutiny, they will be exposed as the flawed concepts that they are, and that good ideas will necessarily percolate to the top. But we also know that's not always true. And in an era where more and more people depend upon limited sources for their news and information, at a time when they could turn to virtually anything in the world, but they'll go back to the ones that reinforce the views they already hold, we can see that this is making it harder and harder to have this debate and discussion, which the founders of this country and the drafters of the Bill of Rights thought was so essential to facilitate that search for truth. Government, we know, can and will control and manipulate information. One of the reasons we have Freedom of Information Acts is to force the government to make information that's been collected and stored with our tax dollars, make it available to the public. Why? Well, in a case of a number of years ago, the U.S. Supreme Court said, so the public can find out what the government is up to. So we know that this is a fundamental check on keeping government honest and keeping us informed about what they're doing. But freedom of information only takes us so far. We have to be able to then do something with the data that we get. And the concern about doing away with New York Times versus Sullivan is that it will be very risky to do so. Any determination of truth or falsity that's left in the hands of the government, I think, that fails to recognize the fundamental right of the citizen to criticize without fear is fundamentally flawed. And so, respectfully, I disagree with President Trump when he says that our libel laws are un-American. I think that our libel laws are the essence of American values, and they're values that we must preserve. Thank you.
It's a long walk. I'm going to need a drink of water. I hope that slosh of water was amplified through the microphone. I don't know if it was. So thank you very much, Jane, and I want to ask a couple of questions just to kind of get the juices flowing before we turn it over to the rest of you. And I want to pick up on a kernel that you sort of that you identified a little bit close to the end of what you were talking about, where you were saying that the kind of the risk of just fighting a libel suit is something that that will often turn people away, right? That just even kind of the risk of being sued, even if you're fairly confident that you would win, will create a chilling effect. And there was an interesting development that you didn't get into too much, because I think it's kind of a little bit oblique to the topic of libel, but it's become something that I think has played a big role in the in defending against libel suits, and that's anti-SLAPP laws. And so I'll just very briefly kind of talk a little bit about that, but I just want to sort of set you up. So an anti-SLAPP law is a law that's intended to prevent the a strategic lawsuit against public participation. Often the public participation is publishing in the public interest, but it doesn't necessarily have to be. And often the lawsuits that trigger these anti-SLAPP laws are defamation lawsuits. 33 states have anti-SLAPP laws. 2 states, Minnesota and Washington, have ruled them unconstitutional, so they're not without sort of legal controversy or sort of legal challenge. But amidst this sort of upswing of libel cases across the country, something that people have called for, some commentators and legal minds and others have called for a federal anti-SLAPP law. I think there are some unique challenges to that, but I think there also could be some unique benefits to that. Can you talk a little bit about sort of what your thoughts about that would be?
this on? Is she
I'm not
saying?
hearing it.
I'm not hearing it.
Oh, yeah?
Yes? No?
See if your green light's on.
Green light. Well, they told me it was. Yeah, there we go. Sorry. They told me it was on. I just assumed it was. Again, the philosophy about these laws is that powerful interests, whether it's a government official or, in many cases, a big corporate interest, can suppress criticism simply by the threat of a libel suit. Because as I talked about, in other countries where they don't have the robust protection that we do, you can face huge damages. And let's face it, when McDonald's is suing somebody, as they did in England, for criticizing the quality of the ingredients they use in their hamburgers, McDonald's doesn't need a huge libel judgment. They don't need that money. But it's a tremendous deterrent against criticizing them in the first instance. So recognizing that even in this country, where a libel defendant can often, or a libel plaintiff can often get a lawyer to represent them on a contingent fee basis, which basically means you don't have to pay any fees, you just get a chunk of the damages, if any, and that goes to the lawyer. It can be pretty intimidating to take on a big company like that to try to defend yourself, because unless you can find a lawyer who'll do it on a pro bono basis, you're going to be up for paying those big fees, even if you win. Federal level, this would be the federalization of a concept which, as you said, has caught on in many states, but, as in Minnesota, has been found to be unconstitutional. So while I think there could be an advantage to a properly crafted federal anti-SLAPP law, I think the opposition to it will be extreme from both the special interests that influence Congress so much and probably from the congressmen themselves, congresspeople themselves.
Sure. Okay. Going off in another direction, I also kind of want to, through this question, signal to folks that we don't necessarily have to have questions about libel or privacy or those things. That sort of your expertise is in media law generally, and so we can ask questions about some of those sorts
I'll
of things.
talk about anything.
And this also is a question I like to ask our First Amendment Forum speakers. What would you say is the most important Supreme Court case on the First Amendment for us to understand right now, and why would that be?
I think before we found out that Julian Assange has been indicted, I probably would have said either the Neer versus Minnesota case or New York Times versus Sullivan. Neer, because it set up the proposition that prior restraints on the press would be presumed to be unconstitutional, which is a pretty novel view in this world, because in most countries, a prior restraint is okay, and it's up to the news organization to prove why it shouldn't be imposed on them. When you couple that with Pentagon Papers, we have an almost impenetrable view of no prior restraints. So those are both really, really important cases. And then, of course, New York Times versus Sullivan for all the reasons I said. So I think I'm drifting now into Pentagon Papers territory, because although we're not dealing with a prior restraint on Julian Assange, there are very important unanswered questions in Pentagon Papers that might be answered if Julian Assange is ever extradited and brought back to this country. And specifically, and you've heard me say this before, it seems to me that when you look in the long term of what's going to happen as the government and the press battle over national security, classified information, and so forth, we know that it's almost impossible for the government to stop you from publishing if you get the information. That's what Pentagon Papers says. But what we don't know is whether journalists can be prosecuted under the espionage statutes if they publish. The Supreme Court left those questions tantalizingly unanswered in the Pentagon Papers case, although several of the justices said a properly crafted statute, it might be okay. Now, Julian Assange raises the question of, is he a journalist? Is WikiLeaks a journalism organization, or is it something else? That will make whatever answer flows from this perhaps somewhat ambiguous. But I think however it's answered, it's going to be a very important question in this long, long unanswered question of whether a journalist publishing classified information is subject to prosecution under the espionage laws. So right now, I'd say Pentagon Papers.
Okay, all right, thanks. So we'll open it up to your questions. I have two requests of you. One is to wait for a microphone to come to you, please. Since we're recording this, we may not pick up your voice on the recording if you don't speak into a microphone. The other is please ask a question. Make your question a question, please. And we're going to make Ben run all the way to the
Right,
back.
the mic runner always gets so much exercise at these events.
So, is this on? Testing. Okay. So, on your Edinburgh proposal, could you please elaborate on that? On, say, regardless of whether or not it was false or reckless disregard for truth, shouldn't a news organization be compelled to publish the truth with what do you call it?
Well, if I can interject, because maybe I wasn't clear, so I'm happy to try to clarify. The idea was that when you had a ruling like New York Times versus Sullivan, it basically turned away from what historically had been the central question, which is what you published. Was it true or was it false? And turned into the question of whether the news organization that published it had done so with knowledge that it was not true. In other words, we know it's false, we're publishing it anyway, or with reckless disregard, meaning we really don't care if it's true or not. You know, we're going to publish it because for whatever reason, we think it's important, or we think people are discussing it. I remember many years ago when Matt Drudge was first getting started, he published a story about a White House staffer named Sid Blumenthal, who, according to the rumor that Drudge published, beat his wife. And when Drudge published it, and people said, that's not true, it's false. Drudge's response was, well, it's what people are saying. It's the rumor that's going around, and that's newsworthy, and that's of interest, and it doesn't really matter whether it's true or false. So the Annenberg proposal tried to turn it back to that central question, which is, was it true or was it false? And that's why they split it. Their proposal was to split the trial into two parts. If you are able to prove truth, then you're done. You don't have to do anything further. If you aren't able to prove truth, then that allows the further probing into the journalist's conduct. So that was the idea, to kind of get it back to what they saw as the essential question and what they believed most libel plaintiffs were really seeking, which was not money damages, but vindication. You know, that's a really, comforting way to look at it, but I think the problem is that, at least when we're talking about public officials and to some extent public figures like powerful corporate interests, they're probably less concerned about the truth than their truth, the truth that they want to have out there, that they have cultivated, that they have put out and tried to get people to accept. And that, as I suggested, is something that's often very difficult for the courts to determine. So it sounds simple, but I don't think it is simple, and I think that's part of the reason that it hasn't really gained much traction. Another one up there.
I want to ask a question about how you see the blurring of reporting and commentary, and how the American public may or may not be sophisticated enough to decipher that. And I want to cite a specific example. Andrea Mitchell is a respected journalist and reporter. And Andrea Mitchell, on Andrea Mitchell Reports, is a commentator. She reports the same stories that she comments on. Can the public decipher which Andrea Mitchell is doing that?
That's kind of a rhetorical question on your part. I think the answer is that many people in the public don't seem to be able to do that. There are a variety of organizations, news organizations out there, I would say primarily cable, but not exclusively so, that do, as you suggest, blur the line between news reporting and commentary. Even the most polarizing entities like Fox and CNN and MSNBC have shows that are labeled as news shows. You know, and then they have shows that are not. I mean, Sean Hannity does not claim to be a journalist reporting news. He's a commentator. Rush Limbaugh was asked years ago, do you consider yourself a journalist? He says, no, I'm an entertainer. But ask the people who listen to them and who watch them what those people are, and they're going to tell you that they're reporting the news. So I think there is a blurring in the perception of many people in the public, some of it deliberately fostered and some perhaps inadvertently. In the olden days, when people got their news from print newspapers, most newspapers in this country made a distinction between their news reporting and their editorial and op-ed sections. I mean, you could see the delineation. It was two different parts of the paper. It was crystal clear for anybody who cared to look at it to make that distinction. That's a much harder distinction to make today for most people. And when you add to that the fact that more and more organizations are identifying themselves as having some particular political viewpoint, and people gravitating to the ones that reinforce the views that they already hold, you can see how this helps to entrench those into the idea that it really is, it's binary. It's either true or it's false. It's right or it's wrong. And the nuance is getting lost. And I think, you know, one of the obvious causes of that is what I would call lack of skill with critical thinking. And, you know, we can point fingers. I think that there are deficiencies in our educational system that make it difficult for people sometimes to draw those distinctions. And why does that matter? It makes them very easily manipulated. You know, people who will tell you, I don't trust the news media, I always ask them, well, what do you mean by that? What are you defining as the news media? And the answers are sometimes pretty fascinating. Looking at the students in this room, I suspect that many of you do not get your news from the conventional sources of news that I grew up with and have adopted. You probably get them from some form of social media or news aggregators or something like that, who may get the news from a whole variety of sources that you may not vet and not know how they vet. And if you don't know where the news is coming from, then you are very, very vulnerable. You know, the example of Russian and other foreign actors playing on and exacerbating the divisions that already existed in our society to cement them more into place is a great example of how susceptible many of us are to that form of persuasion. It's not news. You know, it's just not. It's fake news, not anything else than that.
If I may, if a natural kind of outcome of that problem that you've identified is that people would say, well, then obviously there should be a legal solution to this problem. What would you say to that? I mean, that, you know, this looks like a problem that law or regulation or public policy can solve.
And I think, you know, we're already seeing some manifestations of that in Congress, where particularly the Democrats are calling for all kinds of investigations into Facebook and other social media platforms, which, you know, play this kind of peculiar role in our public discourse. I mean, let's set aside their collection of your personal data for exploitation and just look at when they're trying to pretend to be news platforms, because that's what I think they are doing. They're pretending. When it's convenient for them, they will say, oh, we're a public utility and we're just carrying what people give us and we don't exercise any kind of editorial judgment. But if they think they can benefit by the First Amendment, then suddenly they're the great champions of news. We've seen how vulnerable they've been to exploitation and therefore their users. So it's tempting to say, we've got to regulate them. We've got to stop them from doing this. My own feeling about that is that it's the natural consequence of companies that have not traditionally been in the news business taking over news delivery. You know, these folks are technical. They're technicians. They're technologically based companies. They want to turn you into, you know, something that they can exploit. News is just one other way of doing that, but they don't bring to that what I would call almost the altruistic vision that I think is essential for journalism. I mean, you have to want to find the truth, not purely to monetize content, to heighten your products. So anyway, long way to answer your question, as I think there's great hunger on the part of Congress and arguably of their constituents to try to regulate. And I won't deny the egregious nature of some of these things that have happened, but the problem is I can't come up with a scheme that will do that satisfactorily without running the risk of government suppressing speech with which it disagrees. We're already seeing that happen in Europe, and we cannot assume that we are not vulnerable to that as well. The First Amendment only means what the U.S. Supreme Court says it means. And I'm not confident that this court, or frankly really any Supreme Court in my lifetime, would necessarily extend the First Amendment to cover this situation. The signs are not entirely unfavorable. If we think back to one of the first cases where the Supreme Court looked at the issue of the First Amendment and what was then the internet, the ACLU versus Reno case, where the court said that speech on the internet enjoys the same protection as the printed word, which gets the highest level of protection under the First Amendment. But are they going to see these things as comparable to that? I don't quite know. But again, I don't trust the government to decide what the truth is. And if they're going to start regulating these platforms on the ground that they're not telling the truth, that's what's going to happen. And there's another hand down here in front, so don't forget the folks up here front. Those who are brave enough to sit in the front row are entitled to ask a question. Yes, up there.
Good evening. What about licensing? Would you speak to the possibility of our industry maybe setting its own standards, policing itself? You're an attorney, you have the Bar Association, the medical professionals, they refer to different health entities when ethics are questionable. Would that work in our industry?
Whether it would work in our industry or not, I guess, is a question that's subject to debate and discussion. The Society of Professional Journalists has one of the most widely used codes of ethics. The Radio Digital News Directors Association, or whatever they call themselves now, they changed the order of the letters, has a code. Public Relations Society has a code. But here's the thing, they're not enforceable codes. Even if they're enforceable in the context of a particular news organization that has adopted the code, it only means that they could fire an employee who violated it, but it wouldn't stop them from going and getting a job somewhere else. I'm a lawyer, I'm admitted in 3 states. If I got disbarred in one of those, I can promise you the other 2 states would disbar me too, and I couldn't practice law again. So what's the difference? Why shouldn't we have standards like that? Again, the facile answer is to say, well, the First Amendment doesn't allow it because the government licensing the press would abridge freedom of the press. I'm all in favor of news organizations adopting codes of ethics, but I think SPJ and others would say that their codes are aspirational. They're not intended to be enforceable. They're standards that we strive to achieve. But, I'm hard-pressed to come up with a journalistic principle that every journalist in this country could agree to. The only one I've ever been able to come up with is if we were to say, journalists should never publish something that they know to be untrue, knowingly publish what they know to be untrue. Fake news, I guess, is what we would say. But even that, if you all thought about it for a while, you might be able to come up with an exception even to that rule. So I don't see it as a workable solution. Now, other countries do have enforceable codes of ethics. I've worked in lots of countries that incorporate what are ethical codes in this country into their statutory law, and they enforce it. But again, that's never been our approach, and we've never licensed individual journalists, and I don't think that the models we've seen in other countries would encourage me to suggest that would be a good solution, because sadly what we see in too many countries is the journalists who are deprived of licenses are the ones who oppose the government of the day. So it's done for political reasons that may have nothing whatever to do with the quality of their reporting, or maybe actually has a lot to do with the quality of their reporting. They're reporting the things the government doesn't want you to know.
So goes without saying, we have to constantly contend with the controversy that is accompanied by new ideas and new technology. What? Can you hear me now?
There we go.
Okay.
Very good.
Did you hear me so far?
Yeah.
Okay. So a recent case of this was the State Department's lawsuit with Defense Distributed, which was involved in, they're involved with the 3D printed gun sort of controversy there. The lawsuit specifically, I believe, was about the distribution of files, blueprints, like actual data. And I think their main argument was that the files, the data was binary code fundamentally. And so their argument, I believe, is like a code is speech.
Right.
And we could apply this beyond just firearms. We could say like some crazy new form of bath salts that they want to sell in Florida, and they have the binary code for that information for the new recipe, or anything controversial, right? I mean, hopefully no one makes that, but what have you had the opportunity to give this much thought on code being speech?
You know, there's nothing new under the sun. This issue came up, I don't know, 20 years ago in a slightly different context, where the government was trying to control the export of a variety of, you know, what today we'd call computer code, on the ground that it was essentially a weapon that was being exported. I mean, it wasn't 3D weapons. It was weapons in the sense it was providing information in other countries to people that might turn around and use it in a way that could harm the national security. And you know, the courts have basically struggled with this, but they come down to the idea that if we're talking about, you know, the creation of code, creating things that might be copyrightable and so forth, then we have necessarily to contend with the First Amendment. Now, as we talked about, the First Amendment does not protect all speech. There are categories of speech that are subject to regulation, can be subject to regulation. And one that comes to mind that I think is relevant today, and probably by analogy to what you're describing, is true threats. True threats to people's safety can be subject to regulation. That's a very narrow category, but it can be subject to regulation. Incitements to violence under specific circumstances can be. So I don't know how this will eventually play out, but I would say that so far, that the scale of the balance is probably tipped toward protecting that speech, even if it can be used for bad things.
Jane.
Hi.
If the light's on, they'll get you.
Hi there. So you had mentioned that courts are better suited at finding or pursuing justice rather than, you know, looking for the truth. However, as we know in the law, the jury is tasked with finding facts. So wouldn't a libel suit be a perfect case to go to the jury? And if not, do you distinguish between fact and truth?
That's a great question. Yes, I think I probably do, because I think you can look at a series of facts and two different people can come to two very different conclusions about what those facts mean. I mean, let's use a current controversy, like humankind's contribution to global warming. We can look at the same set of facts and reasonable people can come to two different conclusions about it. I guess I'm always anxious about there being a governmental pronouncement, even if it's a jury of lay people, about, yeah, this is true or this is false. Certainly there are some things that are palpably true, false. I mean, as far as we know, sun rises in the east, sets in the west. That's a truth. But when we get into many of these other issues, I think we are on, you know, an evolving continuum. And again, as I said, because of evidentiary rules, and just looking at some of the more recent libel laws or libel cases that have come down the pike, I think that juries sometimes struggle with getting to the truth for a variety of reasons, probably beyond the scope of this discussion. So I don't have a lot of confidence, and that's not disrespecting the jurors. I'm just saying that the structure of court proceedings, I think, is not particularly conducive to getting to truth and falsity. And the other reality, and this is probably more significant than I'm giving it credit for in my remarks so far, as the law is currently structured, truth is sort of beside the point. If a news organization is in a situation where they've been caught dead to rights of getting something flat out wrong that nobody can dispute, I can almost guarantee you that case will never go to trial. It'll never go to a jury, because no news organization in its right mind would subject itself to the vilification it will get from that jury, which will bring to that case all the resentments it has against all the news media in the country. You'll settle that case. So the vast majority of the cases that go to trial today have very little to do with determining the truth.
That was easy. So New York Times versus Sullivan was sort of this breakthrough, right? I assume it didn't come out of the ether just one day. And was there a preparation beforehand by legal scholars, academics, and other people to try to figure out a way to put this kind of structure in place that would allow more of a free exchange of ideas before the court got it?
Well, the answer to that is there were some states that had some version of actual malice in their law before it went to the U.S. Supreme Court. So no, Brennan didn't just conjure it out of the air and say, oh, actual malice, there's a phrase no one will ever understand, let's use that, just to confuse the issue. No, it wasn't. But the key factor was that it was constitutionalization of this, elevating it to a principle that applied not just in the states that chose to adopt some variation on it, but was mandated by the very existence of the First Amendment itself. That's what changed the shape of the world. And there are those who would say, and I agree, but you don't have to agree with it, but that it was very much a product of its time. Had we not been in the midst of the civil rights movement, had we not been facing this very serious threat to news media that were speaking truth to power and challenging the system and reporting perfectly truthful things about what was happening in the South, but which those in power did not want to be told, would Justice Brennan, however clever he was at building coalitions and persuading his fellow justices, would he have been able to buy this? I don't think so. I would like to think so, but I think this was a product of its time. And so when you combine those two things together, you had a very potent cocktail that led to the adoption of that standard.
I think we're all the way in the back.
I'm at risk of
Insist on the microphone. Go with the result.
sorry.
No, all right.
Meet each other halfway.
Yeah, please.
There we go.
That's excellent, thank
Great.
you.
I'll risk violating Patrick's mantra at the start of ask a question. But
Question mark at the end.
so there are a few of us here that are lawyers, including myself and Jane. And so I guess maybe, Jane, I think it would be insightful if you could address what's the problem with trying to show the truth in a court proceeding? Because I, as a practicing attorney, can recite probably a dozen problems between cost and procedure, combined with maybe the issues of just like writing a story. Wow, you only get so many pieces before you write your story. Going to trial is maybe not so different, but I'd be interested if to hear your thoughts on the ability to prove the truth in court.
Well, I think, you've listed some of the reasons, and I think it really does come down to things like, for example, rules of evidence may prohibit the introduction of perfectly truthful information for a whole variety of reasons. In a criminal case context, for example, if the police have done something illegal to get evidence, it will often be excluded from the trial, even if it's perfectly true. That's an example of the doing justice versus finding the truth kind of issue. And it sometimes is what confuses people and upsets people when they think that the jury has reached a verdict that just doesn't make sense based on what we all know, because of what's been reported in the newspapers. But maybe they never heard that evidence because the judge ruled that it wasn't something that could be heard. There are also practical considerations. Almost nobody would have unlimited funds and resources to get information that would either confirm or contradict the evidence that's already before the court. It's a messy and protracted process. And, judges don't like to have trials that go on for 3 or 4 months. Just looking at the famous case from a year or so ago, the pink slime case that was brought against ABC, this is a case where the case ultimately turned on the question of whether the way ABC reported on the use of pink slime basically suggested that it posed a significant threat to public health and safety. And who even knows the answer to a question like that? How do you even begin to decide who's right in that situation? And somewhat inexplicably, in my view, ABC decided to settle that particular case. Part of the reason for that may have been, and I'm just speculating here, that they recognized that trying to plumb into the ultimate question of truth and falsity there was just not something that lent itself to the decision of the jury. So as much as I revere our court system, I think that it is not the ideal vehicle to try to reach these kinds of conclusions. And again, I'm with Chafee, even if we did, why should we give that more credence than our own knowledge? It's like Groucho Marx saying, who are you going to believe, me or your lying eyes? And that's, the question that we always have to ask.
You've already talked about the idea of fake news and how the social media sites tend to, a lot of people get their news from those areas. You've also talked about some of the government organizations who are enacting legislation, New Zealand, Singapore, the European Union. I get the feeling that obviously you're not pro-regulation in limiting Sullivan, but how far do you have a sense that you can speak to of how far you fear this regulation as far as it might go to the point of could social media sites one day be deemed as a news outlet and even held to those type of standards that might create libel?
Yes, this is a short answer. I think so. And, again, by analogy, I would point out that, speaking of the state where I live now, Minnesota, we've had a lot of libel suits, and many of them have been brought against non-conventional publishers, bloggers and others. And some of our court judges have even said, I'm not really sure that the protection of something like New York Times versus Sullivan should apply to this blogger. It's one thing if it's the Minneapolis Star-Tribune, the largest newspaper in the state, but why should Joe Schmo blogger get the protections of this? And I think the logical extension of that is going to be that in countries that don't have, it's not that they don't value freedom of expression, they do, and I would absolutely concede to that, but they value reputation also in ways that I think are kind of incomprehensible to the American mind, but it goes back to what I was talking about, this idea of right to dignity, right to reputation. Sometimes that's enshrined in the constitutions of these countries, so it's just as important as the right of freedom of expression. One doesn't trump the other, but you've got your thumb on the scale when you're balancing these interests. And if a governmental entity can say, as we saw just in Sri Lanka just in the last couple of days, that social media is posing a threat to public safety, what do? We shut it down. The Europeans, I think, given their history and tradition, probably wouldn't do anything quite that extreme, but they could easily turn to this idea of 50 million euro fines if you're not taking it down as quickly as they think that you should. So even in, again, so-called mature democracies, I think there is much mischief that could happen, possibly with completely benign and justifiable motives. But as with so many things dealing with freedom of expression, the devil is in the details. And when you look at laws like that, as someone much wiser than me once said, you have to look at the law not in the way you would hope it would be interpreted, but how the person you least trust would interpret it. And then ask yourself, would you still be satisfied with the result? And for me, it comes down to this. I don't trust government, any government, to act in the interests of the public when we're talking about something as important as the flow of information and the focus of public discourse.
Two quick questions and two quick answers, please, because we're coming
Okay.
right up against time.
Quick question. Some people are referring to me as Joe Schmo blogger. I run a news site in Story County and find myself in the unenviable position of being sued by our county commissioner for defamation. I'm hanging my hat on the definition of excuse me, of actual malice as you've defined it. However, you talked about Julian Assange. People like myself who do have both news and opinion and commentary are under attack for being critical of the the system, so to speak. So I find it fascinating what you've been talking about. But my question is, with respect to libel, when you talk about someone's reputation and you talk about the notion that they're being injured and are being somehow harmed or damaged by whatever it is being written about them, isn't that subjective? Isn't that notion that what people hold in their minds is subjective to, or nearly impossible to prove, and so how can you suggest, in the case of Donald Trump, that he's being injured by these stories, and what are your thoughts on that?
Well, that's a huge question, and our time is limited. So I will, but they're all very important questions. I'm not suggesting that they're not. I just want to do them justice. And I guess I would just say this, that, again, New York Times versus Sullivan was about a commissioner in Alabama who claimed that an article that talked about how the police were treating civil rights protesters harmed his reputation in his community. I mean, do you believe that? I mean, can you imagine that among the quote-unquote right-thinking people in Alabama that what he was doing was a bad thing? They were probably cheering him on. And so the idea that people's reputations can be ephemeral things and even falsely, brought into court, that's clearly the case. And I think, historically, we have certain categories of false statements about people that the courts have recognized as sort of intrinsically harming their reputation without them having to prove it. Saying you're incompetent in your job is one of those examples. But that bumps right up against the court's reverence for political speech and political commentary, which they say deserves the highest level of protection. It's part of the give and take tension that exists in our society, has for at least the last 55 or 60 years. It's not always easy to parse that. But I think that tension is healthy. I think it's good because it forces people to think about what the ramifications of these kinds of things are. So, I guess I would say, can people, trot out those who will say, I don't think as much of this person as I did before that scurrilous post? I'm sure they can. But the default position after Sullivan would be, but we have to protect that speech. There's no such thing as a false idea, the Supreme Court said in the Gertz case. We depend upon more debate and discussion to get to the truth.
One more?
Oh,
Yeah.
okay.
You're not going to let me stop on that inspiring comment? Yes.
You just took it up
So-
another level.
I guess my question is, you talked about how Clarence Thomas wants to revisit the New York Times v. Sullivan case. And my big question was, if this is overturned, what will that mean for different states? Will different states have more protections for journalists? Or will, for different states, or will we have an almost disconnect between which journalists in which states can be protected by law, or if public officials have more power to put lawsuits against journalists?
I mean, obviously, we don't know, but what Thomas is calling for is returning the question to the states. And as I mentioned, some states have chosen to go beyond what New York Times versus Sullivan said in the matter of fault, and said actual malice is something that anybody who sues the news media have to prove, not just public officials and public figures. So is it possible that some states would actually preserve New York Times versus Sullivan standards? Sure. There are a number of states, probably most of them, that have some kind of free press and free speech clause in their own constitution. So based on that, they could have, so it certainly is possible that when all is said and done, we wouldn't see a major change. But I'm not comfortable with that as an outcome. I think the U.S. Supreme Court was right when it constitutionalized libel law, because the very nature of libelous speech, at least about public officials and public figures, means that somebody is calling out the people whose salaries we pay and who have important regulation or regulatory authority over our lives. That has to be preserved, or the First Amendment really means nothing. So I think, with all due respect, that Clarence Thomas is completely wrong about this, and it needs to stay in place.
Please help me thanking Jane.
Thank you.
And thank you for your great questions. Have a good night.